So I hate that mainstream media are picking up right-wing media talking points, so let me correct you a little bit. Yeah, there are 2.4 million FOID card holders in the state of Illinois. 2.4 million people do not have assault weapons. So when you talk about the percentage of people who are filing and registering, it's a much higher percentage than what you've cited of the people who are required to do so.
That's Governor J.B. Pritzker yesterday being asked up in Lake Forest, apparently, about the statistics that we've been reporting here week after week about the gun ban registry. And after a full month, just 0.1%. So not even a full half of a percentage point, just 0.1% of total firearm owner identification card holders letting Illinois State Police know that they have a banned firearm. And that's just the statistic. And while obviously not all FOID card holders have a banned firearm, attachment, or ammunition, it's still, if you look at some kind of benchmark to see a compliance, and they say they're a gun owner, that means that just 0.1%, around 2,400 of the 2.4 million, have told state police that they have a banned firearm. We'll get to the latest here on, of course, the gun ban registry hearing that happened in Springfield yesterday. You've got some interesting questions that were popping out and interesting responses as well, but a lot of the responses seem to be just focused on the frequently asked questions that Illinois State Police have on their website. But I wanted to get to the latest litigation against the state's gun and magazine ban because it's pretty crucial. The federal firearms licensees of Illinois, they did file their amended complaint yesterday, and part of that, we'll delve it deeper into it, says, thus to the extent it does not require an entire registration scheme to be enjoined, this court should at least enjoin enforcement of the January 1st, 2023 cutoff date. I think that's a typo. It should be 2024 cutoff date as applied to those firearms for effectively unlawfully banning protected arms. Otherwise, countless people who lawfully purchased firearms will be turned into criminals overnight at the end of the year or forced to forfeit their firearms. The state cannot meet its burden to defend such outcomes under Bruin. So that's the latest from the federal firearms licensees of Illinois. Let's go ahead and take a look even deeper into just the back and forth. Yesterday, as you saw, we reported that the state responded to a request for a amendment, and they ultimately said that they're going to move forward with this with as soon as possible, FFL filing their amended complaint, and then they'll have until December 1st to actually respond, the state said. So yesterday, Judge Stephen McGlynn in the Southern District granted the motion to amend the complaint. So federal firearms licensees of Illinois did indeed yesterday file that amended complaint. So let's go ahead and pull that up here. So we'll take a look at the amended complaint in some detail. But if you go through, you'll read that says, while tensions have been building for some time, they go into historical record and some writings that happened way back when in the understanding of the Second Amendment. And they go back to even April 18th of 1775. They say the fighting started in earnest when hundreds of British troops marched from Boston to nearby Concord in order to seize arms that were in a cache. And they go on to say, despite being overwhelmingly outnumbered and outgunned by colonial farmers and everyday citizens mobilized as quickly as they could, bringing their private arms to bear and in the defense of individual freedoms, a free state. By the end of the day, these common everyday citizens succeeded in driving the British all the way back to Boston and inflicting more casualties on the redcoats they themselves had suffered. In other words, free persons exercising their pre-existing natural right to keep and bear arms had successfully driven back the preeminent superpower of their time. And I think that's a really fascinating argument they lay out, going back just to highlight the purpose for the Second Amendment. And they go through and spell out a variety of other things in their amended complaint, saying because it's clear that the firearms and ratifiers of the 14th Amendment and the framers of the 14th Amendment, they counted the rights to keep and bear arms among those fundamental rights necessary to our system of ordered liberty. The Second Amendment right to keep and bear arms is incorporated into the Due Process Clause of the 14th Amendment and may not be infringed by state or local governments. courts may not apply a means and interest balance test akin to intermediate scrutiny in Second Amendment cases, they say, pointing to Bruin, the U.S. Supreme Court's ruling last summer. They go on to say that semi-automatic rifles include ones now banned in Illinois, traditionally have been widely accepted as lawful possession, as well as semi-automatic shotguns and handguns. Our historical tradition also makes clear that the Second Amendment exists to guarantee an armed citizenry who can act as a bulwark against tyranny, whether from a foreign invader or a domestic government that disrupts our constitutional republic or violates the individual rights it's sworn to uphold. So then it goes into a bunch of other historical quotes, and we'll just scan through here to see some of these that they pulled up in the actual amended complaint. And these are, again, just some of the things that they've already highlighted. And you can see, they're adding writings from 1861 and 1868 and the reasons why to keep and bear arms from a book in 1880 and 1898. So they really go into depth as to what exactly they're looking at here. But I think also it's important that we look at some of the other arguments they've made, especially when it comes to the registry, because that's that's the crux here. All right, as I said at the top, they ultimately are looking to have the registry blocked entirely. If not blocked entirely, then at least that January 1st, 2024 deadline to be postponed. So if you look at page 23, it talks about how while existing owners of newly prohibited firearms have a window of time to register their firearms, which will be grandfathered in with the owners allowed to keep their firearms, the registration of firearms is unconstitutional as it is completely without any backing in our nation's historical tradition of firearm regulation. As history has taught all too often, registration, always and everywhere, eventually leads to effective, if not actual, confiscation, as occurred in the city of Chicago decades ago. No other constitutional right works in this way. Plaintiffs deserve to be able to continue to possess their lawfully acquired yet now restricted firearms without registering them with the state police. They go on to say that in the emergency rules, which are up for consideration, as you had the public hearing yesterday and another public hearing today and another one down in Caseyville for Monday morning, they're all about these emergency rules for the gun ban registry. And this is, again, something that opened up October 1st. You've got a January 1st deadline, or you could face criminal penalties. Obviously, there's a lot of concern out there. But it goes on to say emergency rules only allow where there's a threat to the public interest. And I think that's interesting. They highlight that, there's not really a threat to the public interest, they say. But they go on to discuss that, they're talking about the safety and welfare of the public, which requires rules to be adopted in a less time frame than would typically be allowed. Why the state police waited over 9 months from when the firearms were actually banned. And we'll scroll down to get to this. It's rather a fascinating argument. These emergency rules took effect immediately. So why the Illinois State Police waited over 9 months from when the Firearms Ban Act was adopted to file those emergency rules rather than making proposed rules under the normal process, it's not explained. Thus, they say, to the extent it does not enjoin the entire registration scheme, this court should at least, and this is in the Southern District of Illinois, right? While they're still dealing with the Second Amendment arguments up in the Seventh Circuit's Court of Appeals, down in the Southern District, they brought the case back to say, we're wanting to challenge the registration now on the basis of violating the Second Amendment and 14th Amendment. There hasn't been an argument of the Fifth Amendment made here yet, and that's the one against self-incrimination, but the 14th Amendment really is all about like due process and a whole host of other things. Anyways, they go on to say, thus, to the extent that it does not enjoin the entire registration scheme, this court in the Southern District should at least enjoin enforcement of the January 1st cutoff date as applied to those firearms for effectively unlawfully banning protected arms. Otherwise, countless people who lawfully purchased firearms will be turned into criminals overnight at the end of the year or forced to forfeit their firearms. The state cannot meet its burden to defend such an outcome under Bruin. Goes on to say that there's been no due process. Yet, Illinois has not provided owners of impacted firearms actual notice of the registration requirement. To plaintiffs' knowledge, the only notice that FFL says in their amended complaints that Illinois provided to the public is the registration requirements posting announcements about it online. Which you got to think that's not necessarily the best way to go about informing people who, are typically waiting for some kind of notification from the mail, right? So it says, yet Illinois has not provided owners of impacted firearms actual notice of the registration requirement. To plaintiffs' knowledge, the only notice that Illinois has provided to the public about the registration requirement is posting announcements about it online. That's insufficient, particularly for a law that prescribes serious criminal consequences for failing to take steps presently for previously completed transactions that were lawful at the time. If retroactive laws change the legal consequence of transactions long closed, the change can destroy the reasonable certainty and security, which are the very objects of property ownership. Goes on to say, Illinois could have easily provided direct notice to the registration requirement to all FOID card holders. Why? Well, because they have their contact information. If you have a firearm owner identification card, they know your address. Several years ago, my FOID card was jeopardized because Secretary of State misspelled my driver's license on my driver's license, the physical ID. And then when ISP was, doing checks as they do with FOID cards regularly, apparently what I had on my FOID card didn't match the street address of my driver's license. So they sent me a note and said, hey, your FOID card, if you don't rectify this, it's going to be ineligible. It's going to be void. And I was like, whoa. So I had to get Secretary of State Police to correct one letter in the street name on my ID that they messed up. It was like a D to a B. They needed to change it back to a D. So that one thing, I got a notification in the mail about that, but I have yet to get anything in the mail about this, especially it being, if you don't register, you could be a potential Class A misdemeanor or Class 3 felony for a second offense. But Illinois could have easily provided direct notice to FOID card holders because, well, they have their information. Goes on to say that, finally, even if actual notice is not required to meet due process mandates, posting emergency regulations online, triggering a 3-month window for affected individuals to learn about it and comply with it, is insufficient notice, temporarily speaking. In sum, they say Illinois has failed to provide sufficient notice to those subject to the registration requirements, which is reason enough for this court to immediately enjoin it, at least until sufficient notice can be provided. So that's the kind of summation there of the Federal Firearms Licensees of Illinois' amended complaint in the Southern District. So again, to recap, all right, I know there's a lot there. Nothing yet from the 7th Circuit U.S. Court of Appeals. Still waiting on something. However, there was a filing that the state did make in the 7th Circuit Court of Appeals. If you recall, we've talked a lot about these supplemental authorities that have been filed. And the plaintiffs have filed several supplemental authorities in the 7th Circuit U.S. Court of Appeals saying, hey, look at Hawaii's butterfly knife ban that was struck down. Hey, look at California's magazine ban that was struck down. Hey, look at California's firearms ban that was struck down. Hey, look at Texas's, I believe it was the pistol grip rule or one of the other rules. They point to these other rulings and say you guys should take these into account. Well, several times also you have the state responding saying, well, the appeals court put a stay on the magazine ban, for instance. Well, the most recent filing from the state, it points to the Miller v. Bonta case because the plaintiffs said, again, they pointed to the 7th Circuit and said, look it over the Southern District of California, which enjoined enforcement of California's restriction on, quote, assault weapons, as set forth in California Penal Code section, goes on. But the 9th Circuit, the state says, has already stayed that decision, which conflicts with the vast majority of decisions address a challenge of the law restricting assault weapons from New York State Rifle Association v. Bruin. And it gives a whole list of other cases where such decisions have gone in favor of certain types of bans. So, again, you've got the state in the 7th Circuit Court of Appeals filing that response to a supplemental authority that plaintiffs filed. So that's still happening in the Southern District. No ruling from those judges in the Southern District about the Second Amendment. But you still have in the Southern District 2 cases, one from Thomas Magg, challenging the vagueness of the registry, challenging the vagueness of the law. That's still pending. They heard that in court last month. So we're still waiting on a ruling from Stephen McGlynn, the judge in the Southern District, on that particular issue. All right. So we've still got that pending in the Southern District. Now we have the federal firearms licensees of Illinois and others, Gun Save Life being included in that plaintiffs group, as well as others. They have now filed and been granted an amended complaint, which says that the registry needs to be halted or at least delayed until proper notification can be granted. And they give out a whole list of reasons why the registry is improper and it violates due process in their arguments. So now Stephen McGlynn is going to be setting out a schedule for that particular argument. So here's the question that's going to be interesting. How indeed they're able to get the briefing schedule in to have the state respond. I think by December 1st is what they say. They've agreed with the plaintiffs to respond to the plaintiffs' amended motion. Are we going to see maybe 2 weeks after that a hearing? And then what? A week after that? It's close to the end of the year. Is Stephen McGlynn going to come through and provide a preliminary injunction to halt the implementation of the registry deadline before the end of the year? Seems that the balls are up in the air, and you're going to have briefs, so there's going to be plenty for us to unpack in the days and weeks ahead. So that's the latest in at least what's happened in the past 24 to 48 hours in the Southern District of Illinois, challenging Illinois' gun and magazine ban, while we're all still waiting for whatever happens out of the 7th Circuit U.S. Court of Appeals. Oh, boy, there's been a lot there. I appreciate everybody tuning in, as always, and you can find me anywhere. Just search Bishop On Air, and we can connect on YouTube, on Twitter, on Facebook. So just find me, and let's make it happen, all right? Stay tuned. We've got tons more coming up, including a review of yesterday's first public hearing concerning the gun ban registry with Illinois State Police.